0508, charged with theft of property. And Mr. Pham has 7 cases, all charged with theft of property with previous convictions, charged with sexual assault of a child, and 24 DCCR. You're charged with obstruction or retaliation, which is a 3rd-degree felony. And Ms. Gilbert, in cause number 26, DCCR 0502, is charged with credit debit card abuse. 26 DCCR 0503, charged with burglary of a habitation. 0504, charged with credit debit card abuse. 0505, charged with credit or debit card abuse. 0506, charged with credit or debit card abuse. 0507, charged with fraudulent use or possession of identifying information. And 0508, charged with theft of property. And what is the announcement?
Judge, I've gone through most of these cases. I've talked to Ms. Gilbert about it. Also about her other situation here. It's going on. She is currently on parole. So there's a parole hold on dealing with her as well. I just need to finish up going through a little bit of some of that stuff. I haven't been on it that long.
No.
But and considering that the offer will be something substantial as far as the resolution, I just need a little time with it.
All right, so I'm going to just do a normal reset. That'll give Mr. Lewis time to get through everything and all of the discovery and all of your cases, go through that with you, and then we'll get an announcement at the next court days. All right, you can go back with the bailiff. Good morning.
Good morning, ma'am.
You are Tan Van Pham?
Yes, ma'am.
And Mr. Pham has 7 cases, all charged with theft of property with previous convictions. And what is the announcement?
Judge, on this situation, he has several cases that he's charged with. We had another defendant of very similar situation, same name, that was on the same docket at one point. And it's questionable if some of these or the other person, to be honest with you, they're both actually from the same area of Port Austin. And so I'm trying to go through all the surveillance just to make sure who's who.
Okay.
So I would at least like.
And it looks like we've got 3 different kind of indictment time frames on these. So Mr. Pham, I'm going to reset your case one more time to give Mr. Lewis time to go through all of that. He'll be out there to visit with you, and we'll get an announcement at the next court date.
Yes.
All right? You can go back with the paper.
You want to give me a laptop today?
Yeah, we're getting reported.
I don't know why they hold me here. I didn't do nothing.
Well, Mr. Lewis will talk to you about that, okay?
Okay.
So what about the 2 new cases?
Well, our offer, Judge, just in
April Smith coming?
In hindsight, was that we would kind of wait to see what the court's position was with respect to safety. Those were actually on the grand jury cart at last docket. I have since been assigned them, and so if we need to plead to one or both of them, we can do that. Expedite her to safety if we go that direction. Otherwise, the offer was to for 2 years stay jail on the probation case and to plead to at least one of those offenses so that there's the priors in her history.
Right. But I think when the pleas were done, those were abandoned at that time because they haven't been presented.
Correct.
Presented.
I don't even know that we have them in the office. They have since been indicted last week, and I now have them and can prove them up by next week if the court would like.
Well, what's your client's position with regard to that offer of safety?
Oh, she definitely wants to do the safety.
Then I want pleas of everything today if I'm going to do that. She's got to take responsibility for those new cases if y'all want to get the paperwork done for whatever agreement you've reached on those. But I don't think dismissals is appropriate.
No, and that wasn't the plan.
Okay.
When we didn't have them,
it
was let's not hold her up for safety, but now that we have a cause number to plead to.
Yeah, we need to get them all taken care of today. All right?
We'll take care of it.
Yes, sir. I'll hold it.
Thanks.
And then you've got Jordan Thomas.
Judge Thomas.
Jordan Thomas.
Jordan Thomas.
Good morning.
Jordan.
Good morning. Been waiting all morning.
I know.
And Judge, this is when I was retained on right during that transition when Ms. French took over those cases on. So we've had a little time to talk, but not much.
Good morning. Are you Jordan Thomas?
Yes, ma'am.
And this is cause numbers 24 DCCR 0487. Mr. Thomas is charged with sexual assault of a child. And 24 DCCR 2178, charged with aggravated assault with a deadly weapon. And Mr. Lewis, what is the announcement?
Judge, this is one I've been previously retained on. Recently.
Yeah. Okay, I see that.
Retained on. I got on this case. I've talked to Ms. French a little bit about it. She's reviewed it over the weekend, actually, and gave me an offer this morning.
Okay.
In regards to where you are, I do have discovery. So I just need to go sit down with Mr.
Sure.
Thomas.
Okay. We'll just do a normal reset, give you plenty of time to go over everything with Mr. Thomas, and we'll get an announcement at the next court date.
Yes, ma'am.
All right, Mr. Thomas, we'll see you at the next court date.
All right.
And I'm holding April Smith. Okay. All right, sir, you're trailing Hill.
Yes, ma'am.
And Mr. Hill, in cause number 24, DCCR 1500, you're charged with obstruction or retaliation, which is a third-degree felony from June 2nd of 2024. What that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yeah.
And then in cause number 24, DCCR 1614, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from July 15th of 2024. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? I'm sorry?
I was notified. Yes, ma'am.
Okay, I just need to make sure you understand. Just yes or no, okay? Cause number 24, DCCR 1615, you're charged with aggravated robbery from July 15th of 2024. That's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life. Do you understand?
Yes, ma'am.
And then finally, in cause number 25, DCCR 0436, you're charged with a second-degree felony offense of burglary of a habitation from June 19th of 2024. That means that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
In all of those cases, I have here on the tablet some documents that you've signed with Ms. Perazzo that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases for a 15-year cap on the aggravated assault, aggravated robbery, and burglary of a habitation with a dismissal in the obstruction or retaliation. So that means you would be leaving your punishment up to me in those 3 cases. And if I followed the agreement, I could not give you more than 15 years. I can give you 15 years. I can give you less. It would depend on information that was brought to me at a sentencing hearing. You have every right to reject that and have your cases go to trial and let a jury decide if you're guilty or not and what your punishment is if they find you guilty.
Okay.
Is that what you want to do? Do you want to reject those offers and have a jury decide?
I'd rather reject the offer because I feel like it would be a better choice for me.
Okay. So what I'll do is get your cases set very quickly for trial. Mr. Nichols, what is the state's position with regard to which case or cases would be?
Expected to proceed on the ag robbery, Your Honor. It's the same incident as the aggravated assault. I may join them.
Okay, but
But
so,
I tend to go forward on that case first.
all right, ag robbery, possibly the same one.
And I know that with the age of these cases, even on its first setting, it should expect to be breached, Your Honor. So we'll be
Yes.
ready for trial.
Okay, perfect. Same thing. Obviously, I've asked Ms. Perazzo to get up to speed very quickly on these.
Yes.
That first trial setting is likely to be it going. So we need to get these taken care of and Mr. Hill either out of jail or on his way somewhere else.
Yes, ma'am.
All right. Okay, we'll set them for trial. You can go back with the bailiff.
Thank you, Your Honor.
Mr. Hill, wait real quick before you. I do also want to make sure you understand that after today, I will not accept these agreements. So we'll put your case on the trial docket. We'll get it tried very quickly, but you're not going to come back in later and change your mind unless it's just something different than what the offer is today. Do you understand?
Yes, ma'am. I'm trying to get, after paying Mr. Burbank that much money, I was hoping I could have got a better offer in the process.
Well, this is what the offer is. The offer is not going to change. So I want to make sure you understand that holding out till trial or anything like that is not going to get you a better offer.
Yeah.
This is what the offer is. I'm not going to accept it after today. You understand?
21 hearings.
All right, go back with the bailiff. Okay, you're April Smith?
Yes.
And will your client waive the formal reading of the indictment in each of those new cases?
She does, Judge.
Ms. Smith, in cause number 26 DCCR 0870, you're charged with the state jail felony offense of possession of a controlled substance, methamphetamine, from May 1st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? So we're going to go to, I don't need to, pre-sentence report, I don't guess, on these new ones. Correct? Okay. And then in cause number 26, DCCR 0871, you're charged with the state jail felony offense of theft of property with previous convictions from May 1st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with. That indictment also alleges that you were previously convicted of theft August 1st of 2001, and then February 7th of 2003, then August 12th of 2005, and then February 6th of 2013. And are all of those prior convictions for theft true? And did you enter your plea of true freely and voluntarily? In each of these new cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreements that you've reached in each of these cases are for 2-year terms in the state jail prison that would be probated for 5 years. There would not be a fine. I don't see that y'all wrote on here safety, but that's part of the agreement, correct?
Yes, ma'am.
And it's also part of your agreement, and I'm going to write it in as well, that you enter and successfully complete the safety program. Is that your understanding? State tenders number 1 in each of those cases?
No objection.
It's admitted in each case. Is there any evidence that Ms. Smith is not competent?
No.
All right, Ms. Smith, in each of those cases, I'm going to find that you entered your pleas of guilty and then true freely and voluntarily. Find sufficient evidence to find you guilty. And cause number 26, DCCR 0870, find you guilty at this now of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that'll be probated for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the safety program. Cause number 26, DCCR 0871, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the safety program. Then, I need that sentencing back, please. In cause number 19-33472, you were previously here in court. You entered pleas of true to counts 3, 5, and 6 in a motion to revoke your probation. You're on probation in that case for the state jail felony offense of theft of property, and that was from August 30th of 2020.
Same question, Judge. I was going to ask the court's guidance. I don't know that because it's that level of an offense, if the court can't extend it, I would hate for it.
I can extend a state jail felony up to 10 still.
Okay.
The problem is the length of time that the motion has been. So she would have 5 years. She would have August of 2025 would have been the end date. We're not to August yet, so we're still okay. I've got a year.
Yes.
So we're
And
okay.
it was filed in May of 25, so it actually told it right before it technically expired.
Yeah, but even with tolling, if you have a year past that, then you're just shot up.
Right.
So we're good. Okay. So we reviewed that pre-sentence report. We talked about this last week. I think reset it, and it's everyone's suggestion that I continue this probation, obviously extend it, and order safety as a condition. Is that correct? And Mr. Riley's here, and I'm not Mr. Riley, sorry, Mr. Kitchens is here, and you are the probation officer for Ms. Smith, and is this your recommendation?
Yes, that's correct.
Okay, thank you, sir, for being here. Sorry, I called you the wrong name. So, Ms. Smith, I am going to find in cause number 19-33472 that you entered those pleas of truth freely and voluntarily. Find sufficient evidence to find you guilty. Or was she already guilty on this? Was it
That was a straight.
It was straight.
It was a straight.
It was a straight. So find sufficient evidence to revoke the probation. However, I'm going to follow the agreement that you've made and continue you on probation. I'm going to extend the probation in this case for 3 years. I'm going to order in this case that you enter and successfully complete the safety program. So if you do all of this correctly, you are being given a chance of a lifetime today. You've already seen my response and that I don't really love all of this, correct? What that means is that if you're back in here on a motion to revoke, I'm going to look at all of this and wonder what I was thinking. And it's going to make me really mad that you made a fool of me for going along with this. So please don't do that. Okay? Take advantage of SafeP, get clean, and then you can serve all of these sentences while you're out on probation instead of in the state jail prison, which is where you'll end up if you violate, okay?
Judge, may I I'm sorry, add one thing for the
Yes.
record for Ms. Smith. As the court told you, and I mean no disrespect by this, but she's going to be just as mad at me for asking her to give you the chance as you. And so when you come back, if you come back, I hope you don't, other than to tell us you're doing great, I will be asking judges that these run consecutive. And you know I've been here since 2020. It's still going to be me here in 3 years. So that would be the recommendation of the state at that time, Judge. I hope it doesn't come to that, but
I do too.
that's why we're giving her this opportunity.
Take advantage of this opportunity. We all want you to be successful. I'm handing you the trial court certification in all 3 of those cases that shows that these were agreements that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right? Good luck to you, ma'am.
Thanks.
In this courtroom session, multiple defendants faced serious felony allegations ranging from theft and fraud to violent offenses. While several cases were delayed so attorneys could review evidence, one hearing stood out above the rest. April Smith, already dealing with probation issues and newly indicted charges, chose to accept responsibility and plead guilty to multiple offenses. Rather than sending her immediately to state jail, the court approved a probation-based resolution that included mandatory participation in the SAFPF rehabilitation program. The judge made it clear that this was an extraordinary opportunity and warned that any future violations could result in significant consequences. Meanwhile, another defendant rejected a plea offer that would have capped potential punishment, choosing instead to take his chances at trial despite facing charges carrying possible decades in prison. The hearing highlighted a recurring theme seen in criminal courts: the difference between accepting accountability and rehabilitation opportunities versus risking far harsher outcomes through continued legal battles. In the end, the judge emphasized that second chances are valuable, but they come with strict expectations and consequences if they are wasted.